Morning, Judge. I'm approaching on Jaime Estrada.
Okay.
He's here for a taxation of his job. I think he's paid all the fees, but we're still waiting.
Are you ready? Have you just received word that he's paid everything as well?
So the only thing about that, I feel this render sometimes reading on college team. So that's the page of that.
Okay, so do you have anywhere else to go?
Well, I do have to run to URD. What time does that usually mean?
12:30-ish. You know, I mean, today's a light day, so maybe 12. Um, I don't know, we haven't gotten word. I'll just roll with you tomorrow to see.
Yeah, I was just gonna say that if we, it's not like we're still waiting, if we roll it, can we wait till he's here today?
Does he have a receipt that he's there? Have you asked him? Yeah, see if he, because they're going to give him a receipt anytime you pay, you know? He should have a receipt. Yeah, see that, and then so that we know that he actually paid, and then assuming that he did, then yeah, we'll withdraw. Oh. Come up, Mr. Lestrade. Let's do this. I'm not going to do anything until this lawyer gets here. All I know is get 3 open cases. They're all at 7503 because you continually take off. You come to court when you want to come to court. You don't come to court. Let's wait for your lawyer to get here and we'll see. But all I know is you've got 3 open cases. All the bonds are 7503, which indicates to me that you've taken off 3 different times. So let's see. So just take a seat for me. I mean, I'm not going to argue with you. I'm going to wait for your lawyer to get here, and then we'll go from there. But you're supposed to come to court when the recess sets, not when you want to come. No, you don't come to court. You can come to court, right? But you're supposed to come to court when the recess says. And we have multiple instances of you not doing it. I mean, I don't know how else to say it. So let's wait for your lawyer to get here, and we'll go from there. He got another new one, so hopefully he'll. And he's usually good about showing. So. Right. Ready? How are you? You know. So you want to talk about? Okay. Come up, Mr. Lestrade.
So there's a misunderstanding on so on these old cases, his appearance was required to court. It's when they did the new QB on the new case, which I believe is year and 19. And so that's when I tried to contact him to get him to come here. Gonna get in contact with them to schedule the coordinate with the old cases, and that's when the judge was coordinating just on the phone cases. He said he received the letter, so he came in today. The letter, obviously, we have to receive the letter.
So let's do probable cause on your end of this case, because I don't know anything about it. Mr. Lestrap, you've now picked up a third theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
The officer was Mr. Walker in Harris County, Texas. The complaint, the manager of the Walgreens told officers that he was at the store and proceeded to several items, including a case of beer and a large packet of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees would be offended by naming the sign.
Where is trespass and the theft? The prior trespass and the prior theft. Can you tell me where those are?
Yeah, also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens. Not once, twice. What should I do now, Mr. Lestrap? What should I do? You tell me.
It's just for the employees knowledge. My client is homeless, getting hours, no employment. Had some assistance from his mom, but obviously that's not a whole lot. I don't know if that's the number.
That mom over there?
Yeah, it's not. See it on.
Did you come with mom today?
Okay, see it on.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, find you a place to stay. If you want something to eat, we'll get you something to eat. But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to. For a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you. Every 15 ways from Sunday. Watching your every move. Ray, I'm sorry. I'm not going to give another PR. You know, perhaps, I don't know, but you're not getting it.
Can we at least address the bonds over here? Because I believe the bonds.
Absolutely happy. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today. It goes with you. I'm with you though. I will. Good morning, gentlemen. You are Mr. Lowry. You must be Mr. Benson. All right, gentlemen, both of you have criminal cases, and it looks like you've worked out an agreement with the state and your defense lawyer. Looks like both of you, Mr. Benson, are charged with theft, and you're facing up to 6 months in jail and or a $2,000 fine. And Mr. Lowry, you were charged with criminal trespass as well. You're facing up to 6 months in jail and or a $2,000 fine. You guys, the agreement you have worked out, Mr. Benson, is 22 days in jail, credited for 22 days, so that you are done today. You need to understand that this is an enhanceable offense. If you continue to pick up theft cases, at some point they're going to hit you with a felony, and instead of days, you will be looking at years. From now on, you are now facing a minimum of 30 days in jail. Do you understand? Mr. Lowry, you are with your criminal trespass, they've offered you 122 days in jail with credit for the 122 days that you've done. So likewise, you're also done with us today as well. It will go on your record. You never take it off. From now on, you're facing a minimum of 30 days in jail. You understand? Is this what both of you want to do?
Yeah.
You are giving up the right to a trial, right to compel witnesses to on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, there's no turning back. We'll go on your record and stay there forever. How do you plead to the offer, Mr. Benson? I'm going to find you guilty. I will follow the agreement, send you to it, Mr. Lowry. How do you plead to the offer? Guilty or not guilty? All right. I'm going to find you guilty as well. I'm going to, in the enhancement, just abandon it. Oh, do we need to do it on the chat? Got it. All right. So, Mr. Benson, you have a prior theft from 2019. Is this true? Okay. This now makes two. A third, you're looking at a felony charge. No matter if it's a gum, a big pack of candy, be careful. You'll be facing some serious time next time. You understand? Okay, so true the defense. We'll abandon the other. Good luck, gentlemen. Oh, and Mr. Benson, your second case will be dismissed. I realize that. Oh, yeah.
I was told I needed to approach on this.
We have quite the. Did you represent him before? No. We have quite the history of this gentleman, where he had a couple cases in here, numerous bond violations. He pled not too long ago. No, I think did he get dismissed from the So he's not put in new case. All I know is that he's charged with evading arrest. He picked up a new case on the 30th. And we've gotten emails stating that because of this case, I think he broke his leg in half. That's what he's saying. Broke his knees, tibia, fibia. I don't know. He's provided Victoria some kind of paperwork. I don't know if it's legitimate or not. It appears to be. But I was going to do probable cause number one to see, was there really an injury that occurred? I don't know.
Yeah.
Mine?
Yeah.
Yeah.
On December 29th, 2024, an officer observed another officer driving through a parking lot of 2901 Westridge Street with emergency equipment on and chirping sirens due to a large crowd loitering on the property with no loitering signs. The officer observed in the left side mirror the defendant tossed an object underneath a motor vehicle on the property. The officer made a U-turn and observed the defendant reaching under the same motor vehicle, retrieve the object, and reach into his front waistband as if placing the object. The defendant then tossed the object under another motor vehicle. The officer wearing full uniform told the defendant to come towards him and asked what he had dropped. The defendant walked towards the officer, stating he did not drop anything. The officer grabbed the defendant's left hand and attempted to handcuff, and the defendant took off on foot. The officer chased the defendant, and the defendant tripped on a drainage. The defendant evaded for approximately 100 feet. The officer looked underneath the motor vehicle and retrieved an unholstered black Glock. The defendant was identified by his Texas driver's license.
Did he suffer an injury as a result of that trip and fall? Does the officer notate? Because from what the email says is that he went to the hospital at that time? Is that what that says?
No, and it does not say anything regarding whether he was taken directly to JPC or whether he was taken to the hospital. This is a Houston Police Department case, so we do have the offense report. So,
Do you mind looking it up real quick? Maybe just the DIMS doesn't say it. the emails that we've gotten is saying that he's in such pain and such dire circumstance that he cannot make it to court. But I have quite the history with this gentleman where.
Yes, so he was taken to the hospital due to a blood
Let's say that.
Yes.
So I've appointed you to represent him. If you don't mind reaching out to him to see how bad is it, when can we get him here, how, and we'll go from there.
It looks like he has a felony on the 30th, so I'll see if I can get in contact with him by some company that just so we'll just do something.
Yeah, I'm okay with it.
Right now.
Okay, great. That way you can. Now, one more thing. In the past, he has also emailed me with a bunch of stuff before. So reach out to him. Don't call me. Email. It's been quite. Just please. Okay. I think that's it. I think we're done. What? Oh, and
Great.
yeah, I remember it. You said Garrett? I'm in. You know it. All right, Mr. Lestrap, it looks like you've worked out an agreement. Come on up. I really hope that you heard what I said to you earlier. Every time you go to this Walgreens, they know who you are, every single person. So every time you come back, what do you think they're going to do? They're going to watch you like a hawk. Every single move. You've been trespassed from there. So if you go back there and they call the cops, you're going to be right back in jail. Don't go back. You've worked out an agreement. They're offering you 60 days in jail with credit for the 2 days that you've done on this theft case here. Looks like they're going to dismiss the 2 other thefts that you have. You also need to understand this now makes at least 2 thefts for you. You pick up another theft, you're going to be looking at a felony charge, years instead of days. Giving up the right to a trial, right to compel witnesses to testify on your behalf, front and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you plead guilty. You can never change this. Are you sure you want to do this? Guess that's it, right? Okay.
Or bond. Look at the New York case.
If you can't ever make bond, if you don't have anyone in this life that's going to bond you out, why pick up a criminal case? You know what I mean? When you leave here, Mr. Lestrap, come back. If you want a place to sleep, if you want a job, if you want food, I'll give it to you. All you got to do is come back. But if you keep picking up criminal cases, no more PR bonds. Do you understand? There's no excuse. We will give you resources. All you got to do is come back. Giving up the right to, have I gone through the warnings? You're giving up the right to a trial, right to compel witnesses on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. He was deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there's no turning back. How do you plead through the offense? Guilty or not guilty? I'm going to find you guilty, and I will sentence you to 60 days in jail. I will give you credit for the 2 days that you've done. It's not enhanced, right? Okay. All right. Good luck. Or did you say plead guilty? Really? Please plead to the offense, sir. Guilty or not guilty? All right, I'll find you guilty, sentence you to good luck. Thank you so much, man. Okay. Hi, come on. Yes.
I'm here on Raymond Henderson.
You said Peterson? Henderson. Okay.
I just wanted to know if the court would be willing to give him time, credit for the time he served out of county before he was extradited here.
Sure. Yeah, I mean, young though. No. The case. The case. It's only right.
Yes, new case. He's got about 17 days on credit go to from out of county, and then he also has some credit.
Okay. What offers have you given?
So we gave a 30-day offer. So actually that was going to be time served.
Okay. Yeah, I'm down. Sure. Yes. Hi. Good morning. Happy New Year. More? More with an M. Okay. Oh, he's not.
You ever have another case of that moved Friday? More.
Okay. This is the new case? You want to bring him up? Oh, this is the case. Okay. All right. Good morning, Mr. Moore. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On December 31st, 2024, the officer initiated a traffic stop to the vehicle speeding 61 miles per hour in a mile-per-hour zone after the 6100 block South Highway 225. The officer made contact with the defendant and the driver of the vehicle, and the officer observed an odor of marijuana. The defendant stated someone else possibly smoked marijuana inside the vehicle, and a PC search was conducted. The officer located 3 individual packages with a green leafy substance known to be marijuana based on training experience. The officer located these packages inside a red backpack from the back seat of the vehicle. The marijuana was weighed, and the weight was 2.87 ounces.
Did you say you said speeding? Did you?
He won.
Okay.
So, in regards to the speeding allegation, there were really 2 cars in front of my client prior to being stopped and creating an accident. He had a nice car and was pulled over. And also my client, the police officer asked him about his longer vehicle. He did tell him that he had a key in the car and said that I dispatched, stretched it in my backpack and the bag. They were unopened at the time. The officer did take the bag. He wasn't, he didn't know how to look to smell. He was decided to be marijuana and he takes him for that. So my client did look at it.
But if CBD and it's unopened, wouldn't smell, right? Because it's vacuum sealed.
Well, no. He said it smelled something in the car. But the substance found in the packages, they were unopened. He knows what CBD. That's what he said he found with marijuana. But my client let him know that this is CBD. It's in my backpack. When you search, you're gonna find it. It's gonna be in there. But I purchased it early today from the smoke shop. So when the officer did choose him out of the backpack and asked about it, it's like, well, I can't tell the difference between, you know, what CBD and marijuana is. I only know marijuana, so I'm not to take you in on that.
Form is CBD in.
It was like a little, it was a flower. So
It is a flower.
So I didn't know that the CBD flower and cannabis flower they did similar.
You're
So
wrong, if I may. So, as the DIMS established, so the odor was enough concern, and finding that leaky substance is enough, because upon further testing, it may or may not, but just because of the health.
So I think for probable cause purposes, I think it's enough because the odor, right? Now they're going to test different, then there we may have an issue. And as far as probable cause, and you know, your record itself, Mr. Moore, anytime you pull over, what's going to happen? You know what I mean? Every, what? 1, 2, 3, 4, 5 marijuana case. Anytime you get pulled over with your record, what's going to happen? Every single time. So, why give them a reason? You know, really. They keep coming back and forth and back and forth. Can you run his license if he has one? All right. I'm not going to put any conditions. Careful. Don't pick up any new cases because I'm going to lose it at that point. Just, you've got a great lawyer. Listen to her. She'll take care of you. If she tells me she can't get a hold of you, I'm going to revoke your bond. Be good. Don't pick up any new cases. If you're going to drive, make sure you have insurance. Car insurance, all right? Okay, guys.
thank you.
All right.
这个你是晚上
Okay, it's getting up there, but not up.
So, I just have to say, you know, the last time I like to friendly.
Of course you can.
Yeah.
Sure. Yeah, just talk to Ramona, whatever you want. How's Miss Dixon doing?
She's doing well. She,
Did you finish it yet, or what?
no, her last class is on 12/17. And then she can break and come back tomorrow. She brought her over the break homework and study that. She's still now.
Okay.
She's been working on it. I asked her tomorrow when she goes back to figure out exactly how long it's going to be before she takes the test. You know, she took the evaluation test already and still got it right for the break. So we should now just all day hopefully.
So let's set it off a week to see, and then we'll go from there. And then when we're there, we can do just a longer day. Huh?
Yeah.
Okay, thanks. I know it's all. That's why it's. So what? Come on up.
Good morning, Judge.
You here? Is that him? That's not him, right?
No.
Okay.
I understand that he is still home with his child. I just my doctor's note, but I showed you this. Little.
Okay. Yeah. Struggling. You ready? Hey. Come up, Mr. Harrison.
Yeah.
Was today his regular setting, or was it a setting that we brought him in because he has bond violations? Hey.
We had accepted the plea offer and we're ready to move forward. Before I got that email.
I have here that you have bond violation, Mr. Harrison, in that You were continuing to use alcohol. You are entering into a probation now, and I'm warning you that if you test positive again, I can amend your conditions, and I will put you into a rehab facility. And I can take you there kicking and screaming, and I don't care what is going on in your life. But if you continually show me that you cannot stop, then I'm going to do it my way. And I promise you, you're not going to like the way that I do it. It is a minimum of 9 months if you respond well. Do you understand? But it could be in an inpatient facility for up to 1.5 years. Your life spent with me in jail. Do you understand? If I didn't get your attention enough last time, heed this warning now, because you will not get another one. You are charged with driving while intoxicated. Second offense. They have agreed to reduce it to a first. And I hope that you thank them, because thereby you are now not going to do 5 days in jail, because that would be the mandatory minimum for you if you plead on a second. But I'm going to tell you now, I'm going to keep you on a very short leash. And one false move, they're going to file a motion to revoke. Prove it to me that you violated probation. Get ready. For you to complete a what are you pleading to? With 180 days in jail to be probated for 15 months. As part of the conditions, you will do a offender with the education class. 2 victim impact panels. You must also do a TRAS. TRAS is an evaluation to see what other conditions you may need. If they assess other conditions, which in my guess they're probably going to, you must fulfill those. It can be so much as intensive outpatient treatment, supportive outpatient treatment. Because you're continuing to drink while you're on bond for this case, it may very well say that you may need inpatient. I don't know. But that's what you're agreeing to now. Do you understand? No drugs, no alcohol, random urinalysis. You must maintain a guardian interlock and a $100 one-time donation to MAB. One more thing that you must recognize here, that there is a requirement for a no breath test refusal. If you are driving in a car and you get pulled over, an officer asks you to submit to a breath test. You must submit to it. If you fail to, then they're going to take you to jail and you're in violation of this probation. Do you understand? You give up many rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. This is number 2. What happens the next time, Mr. Harrison? If I had one strand of hair, every time someone told me that it wasn't going to happen, I would have flowing, beautiful locks. You need to know what happens if you get pulled over again and you get charged with another DWI. What happens next time? You will be facing a 3rd-degree felony. You'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, if you even have a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk. You just tell me now, it's not going to happen. You told me you weren't going to consume. Here we are. We've got you on a bond violation. Goes in here, goes out here. The only thing that matters are actions. Your words mean nothing. Actions speak louder than words, Mr. Hirsch. How do you plead to the office of driving while intoxicated, guilty or not guilty? I'm going to find you guilty. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out here in Orange. We're going to have a conversation as to whether you violated this probation, and if you did, you were looking at 180 days in jail. Do you understand? Okay. So The other thing that we have to do is the fines and fees for the DPS surcharge. It's a first, so it's a $3,000 fee. But let me ask you this: is this a .15 or above?
Zero.
And is it alleged? Is it alleged on the information?
I believe it's alleged to be 0.15.
You should be walking out here with a $6,000 surcharge because they reduced it to a first. It's now a $3,000 surcharge. You must pay that in addition to the court cost. If you don't, for every $100 you owe, you will one day in jail. Do you understand? Okay. How do you plead to the offense? I will find you guilty. I'll sentence you to it. Good luck, sir. Thank you. All right. Okay, yeah, we need to do a no driving affidavit. You are not allowed to drive. I don't care what you're doing in your life. You'll be signing an affidavit with me today that you're not driving. I hope you're not driving at all. Take it seriously, Mr. Hunter, because if I catch you driving, get ready. Okay, so if he decides he wants to drive, he needs the interlock before he even gets into a car driving. So we have to amend conditions to be able to do that. So you can't just start driving. You cannot just start driving. You are required to have an interlock in your car. There is a paper that we sent to DPS so that every officer in the state knows that if you drive, you're supposed to have an interlock. If you get pulled over and you're driving and you don't have that interlock, they're going to take you to jail. Do you understand? Okay. Talk to Kim. She can help you out when that time comes. Thank you. So 3,000 plus the court cost. Pay all. Carl, hey. Yes, sir. I did. And when I was 19, my hair was still green. Oh, like. I know. Where the times are gone. Yes. Don't worry about it. Undone? It's not on today? You got a call sign for me? What is it?
854409. You gotta go to once. You gotta go to the and I think we are so I mean, I'm not sure. You're right about it anyway. You said it for them. 1.2 is one and one. Court. It's already, in case it's already
You still with that? Right. So we want to put it, I guess I can just change the date, put it on that day.
I don't put out the values that I know come back this week.
Do you want a different day or do you want that? Okay, yeah, so we can just change the date on that and put the 122 on it and it's. He's in custody. I mean, it's redundant. There's just not. Sure. Yeah. Where is it?
On the case number 489. We should sign up already.
Oh, it's still in ready. Oh.
Yeah.
Got it. Okay. Done. Sure.
So you're going to continue the conversation?
Yeah, I'll just continue because I mean, you know.
What do you want to do?
You ready for cause number?
Oh, yeah.
Hey, what? The possible. I don't know.
We raised it because he had his other two sons. He was
Okay. You say, let me. Hey, Jillian.
She took like, oh, big off, and she has, oh,
Come up, Miss White.
before that time, why I'm there.
You really expect you're gonna blame it on AT&T?
No, sir, I honestly,
You are even lucky to be getting a PTI offer at this point. As many times as you've taken off and the fact that your case is 250 days. We set cases for trial at 180 days, and your case is now 240 days old. What have you offered?
So we also had a 6-month PTI where she had to take a decision-making class in the drugs and alcohol.
Like the long decision-making class?
Y'all like one?
yeah,
If you're gonna do the,
Yeah, believe me, man.
that's what you guys are gonna do, then I'll give her a week to get it done. I'm not doing any more. If you don't have it done in a week, I don't care if you come kicking, screaming, you blame it on whoever it may be. Then you can do it. I'm going to set your case for trial, or you're gonna end up taking another offer, and you'll end up with conviction. But you can't expect good things when you repeatedly take off, fail to communicate with your client, and you just go AWOL. Why would we care if you don't? It's a rhetorical question. You don't have to answer. That's what's going on in our mind here. Why would we care if you don't? You would be given an opportunity now. The ball is in your court. You have 1 week. If you don't get it done in that week, that tells me that you truly don't care, and I won't take anything else. Do you understand? 1 week.
okay.
I gotta go. So last time he was maybe he got a new case of files 1211. He signed a 2 million.
Hold on. So he was here. Last time he was here was
November 13th.
Okay.
That's the last week that he said his insurance was waived, but he didn't say he was. We're not
he
taking
was
on file.
supposed to be here December 2 times.
December 12/19 and 12/26. You signed a bail order saying he was bailed in for both days. And you raised all those cases on the 7th.
Yeah, he was supposed to be here 12/26.
Yeah, that day began 12/19.
Right out of the gate, this sounds routine. Fees paid, paperwork pending, but don't be fooled. In courtroom terms, waiting on certification can mean the difference between freedom today or another reset tomorrow. Stick around because this case turns fast.
You know,
11/13.
11/13.
When we had majors.
Yes, he's here on that.
That was the last day he was here. 12/11.
Oh, he picked up a new case on 12/11.
That's when we granted and ordered. Signed to be on 12. You know, we raised all the bond. But
I was told Miss Galinda was negative. So, I don't know what to her.
She's here.
Oh, she not?
Came up. All right, come up. So I'm gonna give her a portable device now. Okay. She's gotta stick with it.
She's got to tell me after one.
And we'll wait for you today. Yeah.
We'll get my, do portable.
Don't want any more issues. You're on notice. 3 strikes. It's out of my hands. Okay. All right, guys. Good luck. Yeah. You are Mr. Prowler.
No.
Did I say it right? Prowler or Prowler? Is it Prowler? Sir, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Do not afford one. One will be appointed to you.
On December 30th, 2024, the officer dispatched to a doctor's office in regard to a criminal trespass. The officer made contact with the complainant and the witness, and the complainant and the witness had been appointed at the doctor's office several hours prior. He asked to leave, and the defendant said he was not going to leave. The officer found the defendant and the complainant. I found the defendant and the complainant and the witness pointed to him, stating that was the defendant. The officer told the defendant he needed to leave or he would be arrested, to which the defendant refused, stated, "Let's do this," turned around, putting his hands behind his back.
Have a lawyer, sir. Is he coming? Is he coming here today? Let's do this. I'm going to hold off on it real quick. I'm going to have you take a seat. Let's wait for your lawyer to get here, and then don't. Let's wait for your lawyer. Okay, just hang tight for me, take a seat for me, and then let me know when he gets you, and then we'll. Okay, any THAs? All right, we're done. Let's go home. Let's go home. I don't know, let's for now, I don't know, what do you think? I mean, we haven't even arraigned him. That's the problem. Well, I haven't even done an arraignment. I haven't done anything with him. That's why I brought you here, because he hasn't even. We've literally rolled his arraignment for 3 days in a row, and he hasn't even made it here for an arraignment. That's why I wanted to put you on to see how can I even get in here for an arraignment.
Okay.
So I guess Monday? Okay. Yeah. Yeah. Counsel, you ready? Thank you for coming. Come on up, sir. And the name, what was the last name again? So you are Kenneth Allen, correct? So Mr. Allen, we'd start with probable cause, but I wanted to wait. No, over there. So that we get your perspective on it. So, all right, so you stand charged with criminal trespass. You're facing up to 6 months in jail. We're going to do probable cause again now that your lawyer's here.
On December 30th, 2024, the officer was dispatched to a doctor's office in Texas in regard to a criminal. The officer made contact with the complainant and the witness. The both stated the defendant had an appointment at the doctor's office 4 hours prior, asked to leave, and the defendant said he was not going to. The officer found the defendant, and the complainant and the witness pointed to them, stating that it was indeed the defendant. The officer asked the defendant, told the defendant he needed to leave or he'd be arrested, to which the defendant refused, stated, "Let's do this," and turned around, putting his hands behind his back.
The witness.
So, let me see, Your Honor.
I mean, he had authority to be there, and I know that you can revoke, when you overstay your welcome.
Yeah. So, the complainant is the office manager and the witness is.
Did you want to add anything?
Well, that's my issue. She's been at me. So he has worked there for he was there for his doctor's appointment. So there's some potential as far as whether he actually or not, considering that doctor's appointment is month. still feeling again. Sometimes, but so I don't believe that he had a right to I don't believe so that's how I feel about you know what her name was Amy. She's here from she told us. So I think there's
I know, I guess here we have an office manager that's telling him to go, refuses to, so then the security gets involved.
Yeah, he still refuses to want security to get involved. And we've contacted the complainant as well.
You have spoken to the complainant?
Yes.
Oh, okay, tell me.
The complainant said that the defendant was sitting in the lobby after his visit, and the reason they believe is because they had a prior incident where they investigated him doing some inappropriate conduct, and that's why they asked him to leave after his visit had completed, and then he refused to leave.
Do they still want him not to go over there? I mean, I think that there's probable cause for it now. Did you speak to them? Tell me.
They said he's no longer patient.
No longer patient. Okay. So you can't go back there. Okay, Mr. Proler. If you must find a doctor, but it appears that they don't want you to go there anymore. At this particular doctor's office. Okay?
it was just like I mentioned, yes, Dorothy said we're wrong. She don't decide it. No. So court stay away from that. Keep it stable.
Correct. Right. So if you have business in another part of the building, you can go. Just don't go back to this office, because chances are, if you go back there, they're probably going to call the police, and they're going to charge you with another trespass. So don't go back over there, because they've warned you not to go back. If you go back, you can get charged again. Go to the other offices, like, hopefully they're just not next door, because that's going to be a real pain. But, okay, so then just stay away from wherever that office is, and you can use the other two places. I'm not barring you from the building, just from going back to that particular office. What is the confusion?
I want to bring to your attention, there's alleged other incident.
Doesn't matter.
Yeah.
It doesn't matter. The only thing, my concern is going forward. Right. You were on notice now that you're not supposed to go. What suite is this?
The UT position is Bel Air Station, so I don't know how they organize their office. So I think it's just one system. It's not necessarily separate offices like different.
He has two other doctors that he sees there.
I think that's part of the issue because, again, it's part of the same system, so I don't know if you have multiple doctors there, but it would be at the same facility. But they told us that he's no longer a patient at the facility, so presumably that means no doctors there, but we should clarify if you
I think you need to.
Yes.
You definitely need to, because this could be a potential problem.
Yes, we can.
You're saying he's still seeing two other doctors there. They may not know of the other two doctors. You want to do that real quick? Can you give me 5-10 minutes? You see, so, hey, Alex, also see, are there different, in most buildings, there's suite 101, 102, 201, 202. How do they do it over there? Is it by
See how they organize
the suite, and then is it possible that he can see the other two? And then, okay, yeah. Yeah. Sure. Yeah, this is trash. Do you want any of this?
No, it's rather old.
Do you want it? Are you sure? Counsel, come on out. Great. Right. Alex, did you hear this? And Will, this is your deal as well. So they've verified that counsel has verified that he's seeing another doctor at that facility. So what we'll do, like I said, you are on notice of what you can and can't do. We don't want you to go to the complaining witnesses in this over there, wherever they may be, wherever their office is. Do you understand? You can see your doctor. You have another doctor there, but I don't want you to have contact with these people here.
I understand you, Judge. I do need doctor's appointments there, but don't.
How is the facility divided up?
The buildings, it's not, it's not the best building. Yeah, obviously, in terms of concept. You jump LAs or stairwell, whatever, without your shoes, like, kind of wings off. Let's say.
Is there a possibility that you're going to run into these people?
Yeah, I'm sorry, otherwise circumstances.
We don't want you to run into these people.
Yeah, I mean, we say people, is there a way for you to other doctors without going to the car now? In order to. Oh, I'm very, I think I.
I mean, it shouldn't be this difficult.
No.
I don't understand why you're. I mean, what is the doctor's name, or what is? Who are we talking about here?
Talking about Amy Whitetree, so she's the office manager for whatever department she's in.
I don't want you to have contact with these people.
Can I take you on the job? I now know she didn't have to identify herself. I think it was. Yeah. She didn't have YouTube manager. Some woman can be talking with her.
And here's where the judge's tone shifts. 3 open cases, multiple failures to appear. Those identical bond amounts? That's the court's silent alarm screaming. This defendant keeps running. Judges don't forget patterns. They document them.